Dzień dobry Państwu. Przepraszam, nie mówię dobrze po polsku. So I will speak in mediocre English. The first thing I want you to do is to take out this little book which is in your packet. This is the textbook for my speech. I'm not going to read to you the paper that is in your packet. You can read. We're going to talk about it, though. So the first thing I want you to do is to turn to page 22, 21, 22, 22, Article 3. And it says quite simply, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme Court and inferior courts, shall hold their offices during good behavior. Now hold that thought. Turn back one page, and you will find that the President of the United States has the authority to appoint the judges of the Supreme Court with the advice and consent of 2/3 of the Senate. So immediately the question becomes, if the judges hold their office during good behavior, what's bad behavior? Well, bad behavior is not disagreeing with the Congress of the United States or with the President of the United States or with popular opinion polls or with the people. Because fundamentally, and I think we can all appreciate this as judges, what are courts created for? They are an essentially human institution. You don't find courts in an anthill. You don't find courts in a beehive. They are there to make decisions for people who cannot make them for themselves. Period. Now, I realize some of you may disagree with that. But the process of making decisions, given what I've just read to you from our little textbook, does not involve paying attention to bureaucrats and their version of the law if it is in conflict with the Constitution. Pure and simple. Now, we have the case of Marbury versus Madison, which was promulgated in 1803 by the Supreme Court of the United States. And it says, find the page here in a moment, that it is emphatically the province and duty of the judicial department to say what the law is. It doesn't get any simpler than that. And it is this one sentence that forms the basis for establishing the independence and co-equality of the Supreme Court of the United States and the judicial system. That is the basis for the independence of the courts. And then going back in that decision to an earlier point, to what has been addressed in some of the previous comments and presentations, where an officer is removable at the will of the executive, the circumstance which completes his appointment is of no concern, because the act is at any time revocable, and the commission may be arrested if still in the office. But when the office is not removable at the will of the executive, the appointment is not revocable and cannot be annulled. Again, very straightforward statement. So, going back, what's bad behavior? Well, bad behavior is kind of a broad term. For example, A federal judge was removed from office by the process of impeachment, where the House of Representatives brings a bill against that judge, and then the Senate convicts for accepting bribes, really big bribes. He returned to his home state, excuse me, and proceeded to run for Congress, where he now sits as a member of the House of Representatives. Still bad behavior. Another federal judge was convicted of bribery and fraud in the criminal courts. And he was actually entitled to retain his position as a federal judge as he was entering a federal prison to serve his punishment. Now, he had the good taste to resign. He later died in prison. He was also a former governor of Illinois, for those of you who have cousins in Chicago. That's an old joke. But the point is, ladies and gentlemen, once people become judges in the United States, it is very difficult to remove them. And this is of the essence of the independence of the judiciary. I'll give you an example from my own experience. In 1988, there was a case brought in front of me by a group of people who were gay and who were dying of AIDS. Now, the courtroom, excuse me, the courtroom was full of people who had AIDS, and they were coughing and wheezing and dying right in front of me. The lawsuit was brought against the publicly funded hospital in Dallas because they refused to provide a particular drug for free to these AIDS victims. So I listened to the evidence. Actually, I listened to the attorneys argue why the hospital should be ordered to do this. Now, there's a little-known doctrine that, frankly, American courts have inherited from Europe. Some of you are very familiar with it. It's called Parens Patriae. I always tell young lawyers and young judges, this is the doctrine that allows you to make a decision when the book of rules has run out. In America, you'd be amazed how fast the book of rules runs out. But this was a case that had no precedent whatsoever. Nothing to guide the decision except what I believed was right and wrong. So after listening to the arguments of the attorneys, I began to read my decision from the bench, which is unusual, by the way, in American courts. But I had already been writing it out while the lawyers were talking. And I reached a point in the case where I said that from time to time, the court must speak with the moral voice of the community. And that voice is raised in favor of life. And of course, these people all began to cry and hug each other and so forth. And I was ready to get out of there, okay? After I had finished the decision ordering the court to give the drug, I proceeded to leave the bench, and the director of the hospital came up to me and he said, "Thank you." Because I had invaded the political world of the public funding aspect and had done what a court is there to do, and that is make a decision. Now, I'm not going to sit here and pretend that that was easy. It was very controversial at the time. I had all sorts of editorials and newspaper articles written about me and how in the world could he have done that. My own father didn't speak to me for 3 months. It was a happy 3 months. But the independent judiciary can do that. Ultimately, it can do the right thing without regard to the bureaucrats or the city council or the funding or whatever. The Texas legislature provides that the county governments, the smaller local governments, here in Poland it would be the voivodeship, are obligated to provide adequate facilities for the courts. Well, one day, my courtroom was taken away from me. So, I ordered my bailiff, who is the officer who has a gun. I said, we're going to go over to the commissioner's court, and we're going to take their courtroom. And he said, you're kidding. And I said, no, I'm not. So I walked over there to the county government, and they said, well, good morning, Judge Marshall. And I said, good morning. They said, what are you here for? I said, I want your courtroom. And they said, I beg your pardon. And I said, according to the Supreme Court, you have to give me adequate facilities for my court. And so I'm instructing my officer to bring over my flag, and my court reporter will come over with her equipment, and you have an hour to get out of here. And they said, can we talk? And being the reasonable judge that I am, I said, of course we can talk. That worked itself out. But again, the independence of the judiciary was fundamental to that process. Now, don't misunderstand me. I'm not being critical of anybody else's system. I'm simply telling you how this system operates in a very simplistic fashion. And it doesn't require a lot of regulations. The courts are self-governing. The Supreme Court, both of the United States and of each of the state court systems, passes their own regulations about judicial discipline. We have in Texas a state commission on judicial conduct. The members of that are comprised of judges who are appointed to that by the governor. But it's judges passing judgment on judges. No parliament, no nothing like that. Now, most judges are not removed from office by the Commission on Judicial Conduct, but some are. There was a criminal court judge in South Texas where a lot of interesting things happen. And he would sit up there on the bench, and after listening to the evidence, he would take a coin out of his pocket and toss it up in the air and go like this. Guilty. The Commission on Judicial Conduct felt that this was conduct which caused the judicial system to be brought into disrepute. And they recommended to the Supreme Court that he be removed from office. That happened within a matter of hours after the recommendation was made. Again, these are rules that are passed by judges, not anybody else. So, again, I'm not being critical of anybody else's system. I'm simply explaining how this system works. And to that extent, I have to concede, when we're talking about democracy, as Winston Churchill pointed out, it may not be the best form of government, but it will do until something better comes along. And it is messy. But on the other hand, it's not bound by a whole series of detailed micromanaging regulations, such as some of the ones I've heard here. It is allowed to move with the times. This is the common law within the judicial system. As Justice Holmes once said, the life of the law has not been logic. It has been experience. And that's one reason why I'm sure, from the perspective of many of you here today, you look at the American judicial process and you say, that is the messiest system I have ever imagined. Yeah, but it works. Thank you very much.